So can a property under tax foreclosure be quitclaimed? The first answer to your question is yes, you absolutely can deed a property, whether it's a quitclaim deed or a warranty deed, which is what we're going to talk about in this video in detail. But you can absolutely sell a property while it is in foreclosure. It doesn't matter whether it's real estate foreclosure, meaning mortgage foreclosure. It doesn't matter whether it's tax foreclosure. You can still sell that property as long as it hasn't been foreclosed. So as the seller, it's perfectly legal for you to deed the property to someone else, let them buy it. And as a buyer, it's perfectly legal for you to buy a property. Although you do need to be careful and check with whatever state you're working in. Some states have made rules about how much you have to pay for properties that are in foreclosure, and you really have to be careful. So look out for that issue and just talk to a local attorney in your jurisdiction if you're buying properties on pre-foreclosure, because sometimes they limit saying you have to pay a certain amount of retail, so that can be a little bit dangerous territory. But generally speaking, there's no reason in the world that you can't transfer a property that's in either mortgage foreclosure, it's being foreclosed by a trustee, or tax foreclosure. So let's get into the details about quitclaim deed versus warranty deeds, because they're really important. And if you don't say it right, you really seem like an outsider and like you don't know what you're talking about. So let's go through and let me show you how all those things work. So can a property under tax foreclosure be quitclaimed? The answer is absolutely yes, but you may not want to quitclaim it. So let me take this from two angles. Number one, if you're from the angle of the buyer, meaning you're an investor that's looking for a property to invest in, you do not want a quitclaim deed. You want a different kind of deed that I'll tell you about in a minute. If you're a seller, yes, you want to do a quitclaim deed, assuming that you want to get rid of the property. Because what a quitclaim deed is going to do is it's going to transfer ownership of that property to a new person. But there's this confusion among investors about different types of deeds, and investors seem to think that it's a good idea to get a quitclaim deed. Half of them don't even know how to pronounce it properly. You'll hear them say, oh, I got a quitclaim deed. It's not quick, it's quit, Q-U-I-T, quitclaim deed. So first of all, if anybody you're talking to that is pretending they know anything about what they're talking about, and they tell you it's a quitclaim deed, immediately run away, don't listen to anything else they say, and don't ask them for any advice. So a quitclaim deed is one type of deed that you could get. The other kind of deed is called a warranty deed, and those come in different varieties, but the overall is two divisions, warranty deed versus quitclaim deed. Now here's the thing. A quitclaim deed is just someone saying, I transfer whatever interest I may have in this, if any. I'm not guaranteeing I actually own it, but anything that I do have, you can have. So I could give you a quitclaim deed to the Brooklyn Bridge, and it would be perfectly fine, and I would be doing nothing wrong. And you might wonder, well, why would someone do that? Well, you want to quitclaim something if you don't know if you have ownership, you don't know if there are other issues. Like, for example, if you're an heir to an estate. You might say, I'll quitclaim, but I'm not going to make any guarantees that I actually own anything here, so the best I can do is give you a quitclaim deed. So for a seller, it's better to offer a quitclaim deed, but most buyers would never accept a quitclaim deed. Because when you take a quitclaim deed, in the future, when someone looks in the title of that property, meaning looks at deeds going back over time, and they see a quitclaim deed, they say, why is there a quitclaim deed in this? Is there some issue that I don't know about? And that's why you do not want, as a buyer, you don't want a quitclaim deed. You want a warranty deed. What a warranty deed is essentially is someone guaranteeing that they have an ownership interest in the property that they're transferring. So they're standing up and saying, yes, I own this, and yes, I'm transferring my ownership interest to you. So as a buyer, it's much more preferable to get a warranty deed rather than a quitclaim deed. Because as a buyer, when you get a quitclaim deed, when you go to resell that property or refinance that property, if a title company gets involved, which typically they will, especially on a resale, they may look at that and say, oh, wait a minute, we see a quitclaim deed, what's the story behind that? And they may insist that you go to court and bring something called a quiet title action in order to clear up that title and assure them that it's marketable title and you actually own it. Or they may want you to go back and get a new deed signed by the seller, all of which are bad things. So all you have to do is make one small change and it moves from a quitclaim deed to a warranty deed. And all that is putting a paragraph in the deed which offers a warranty. That's all it is. So normally I suggest as an attorney that people do not go and draft their own deeds. Deeds are technical instruments. They're recorded in the real estate records of the county, and they're there forever. So they can create problems forever. It's not a private document that's just sitting in your files. It's something that's out there in the public. So you're far better off having a title company or an attorney prepare a deed for you if you're doing a real estate deal. And typically people asking about quitclaim deeds are people that are real estate investors looking to get to the transfer of a property, usually in a private transaction where maybe they're meeting with the seller who is going through a divorce and just wants to dump the property today, or is under mortgage foreclosure and wants to dump the property today. So the real estate investor will say, all right, sign this deed, I'll give you some money, and we're moving on here. That's fine, but don't use the quitclaim deed. The only time I'd say to use a quitclaim deed is if you're the seller. That absolves you from any responsibility. No one can come back to you in the future and say, hey, there was this problem. You don't want to hear about it, because when you're signing a quitclaim deed, you say, I just give up any interest that I had. I'm not saying I had any, not saying there aren't 10 other owners. I'm just saying I'm giving up whatever I have. But you don't want that as a buyer. So I usually approach things from the buyer's side because I'm a real estate investor. And so I'm usually looking at it that way. And I can tell you, just stay away from the quitclaim deeds and make sure that you're working with warranty deeds. There are different kinds of warranty deeds. Generally, you're going to see a special warranty deed, which is saying that during my ownership, I don't know of any problems, or I didn't resell it to someone else. A general warranty deed, which is the other kind, is the one that goes way back in time, all the way back till from when the land was originally granted. So for example, in Pennsylvania, where I come from, you're sort of guaranteeing with a general warranty deed title all the way back to the time of William Penn, which most sellers don't want to do and shouldn't do for that matter. A special warranty deed is much more common, where you're just guaranteeing that during your ownership, you didn't sell or transfer an interest to someone else that isn't being accounted for. So generally speaking, a special warranty deed is fine, but that's the one that you want. And it's really just one paragraph that's different within the deed. It's not a whole different thing. It's not like a warranty deed is 10 pages and a quitclaim deed is 1 page. It's nothing like that. But also, I will tell you that deeds have very technical requirements, anything from the margins that they have and the language that they have. And it's very easy as a non-professional to miss something and not know what you're doing and make a mistake. So it is very worthwhile to have a title company or an attorney prepare a deed for you if you're doing these kinds of real estate deals. So that's the difference. And please make sure you say it correctly and spell it correctly. It's quitclaim deed, Quitclaim. It is not quitclaim deed. When someone says that, they just look like they don't know what they're talking about. So do not be that man or that woman who doesn't know what you're talking about. So hopefully this is helpful to you. Your next steps from here, if you like this video, give it a like. It's very important this information get out there, that people know how to say the word correctly and what the differences are between them. And the second thing, if you're interested in real estate investing and entrepreneurship in general, ways to make money, then definitely subscribe to this channel. Those are the things that I talk about. Those are the things that I've spent my long career in business and life and doing. I guess I'm approaching 30 years now in business, and I'm approaching almost 30 years as an attorney. Wow, it's a long time. So anyway, I want you to be successful. I want you to have a great life. So let me help you by giving you good, actionable information that's accurate. So this is Attorney Bob Diamond, wishing you all the best. If you like the video, like it. If you want more, subscribe, and I will see you next time.